this webinar, I'll be moderating this session. So a small announcement and a few instructions will be followed by the participants. So kindly ensure your audio is muted and the video is switched off throughout the session for a smooth and uninterrupted run. Please use the chat box for any questions you have for our speaker, which will be duly addressed in the end of the session. E-certificates will be provided via mail for the participants who filled both the registration and feedback forms. Feel free to contact us through the mail ID given in the brochure. To begin with the few lines of the poem Pudumai Pen by the great Tamil poet Mahakavi Bharatiyar, Umiழ்ந்து தள்ளுதல் பெண்ணறமாகுமாம் உதய கண்ணி உரைப்பது கேட்டிரு, which means the best virtue that every woman should possess is fighting for her rights and rising above by making her voices heard. So he was the one who visualized modern women as a strong, independent, and a fully realized human being. So with this, I invite one of the major pillars of this webinar and a dynamic personality, Dr. D. Bhuvaneshwari ma'am, convener of the webinar, Associate Professor, Head of the Department of International Law and Organization, T.N. Dalu, without whose encouragement this webinar wouldn't have been possible. Ma'am, I request you to commence this intellectual discourse with the welcome address. Over to you, ma'am.
Thank you, Parvata, for the sweet introduction. Thank you. A very pleasant good morning to all present and warm welcome to all. The Tamil Nadu Dr. Ambedkar Law University welcomes all for today's national workshop. Topic: Safety of women workforce and students in campus environment. A much needed topic of debate discussion today. This workshop has been arranged by the university in accordance with the UGC directions given with respect to gender sensitization programs. Even yesterday, the university has conducted a topic on the same, which was more practical oriented and utility based. A society is judged by the treatment it gives to women, children, and victims of undeserved want. And it is the second measurement comes with the scientific, technological, or material development. The concept of justice encapsulated in the preamble of the Indian Constitution, it emphasizes social justice. Further emphasized in the judgment of E.P. Rayappa versus Union of India by Justice P.N. Bhagavati as a dynamic concept. The later developments include the concept of mere equality has been converted to substantive equality. That is equality 100% in reality and in substance. Of course, Indian democratic setup is strong enough that empowered women in all spheres, whether we take employment or education, the country has provided all the facilities and all developmental resources. And the Constitution provides the protective discrimination clause as well under Article 15, which is considered to be a transformative form from the mere concept of equality to substantive equality. But in spite of constitutional provisions, statutory or legislative enactments or any schemes or policies prepared by the government, we are still hit somewhere. We are mumbling with respect to one societal issue or problem. What we call it as a plague, a disease, a plague, or an endemic or pandemic. I think it would be comfortable to compare with the COVID-19 because we are hearing that COVID-19 is taking variant forms. Similarly, the harassment or atrocities happening against the children and women are taking variant forms. It has taken nearly half a decade for us to establish substantial equality. Still, the society witnesses the sexual harassment at workplace, guidelines were issued through judicial interpretation, what we call to be the legal realism, and legislations have been enacted, policies of the government projected towards that, committees are formed. But still we are getting movements like Me Too. And somewhere we are lacking, and we have to identify whether we lack with the proper enforcement. And for the past few weeks, we are enthralled by the newspaper, the news that hit the conscience of the entire nation. The harassment in school environment, where complaints were raised by the students, either in school environment or through online classes as well, which has shocked the conscience of the entire country and raises the question, are we building a rule of law based society enshrined by the heart of the Constitution? What we require is a value based rule of law society. So the legislations or judicial interpretations, apart from that, we have to concentrate on still more one more thing. It is the individual discipline and the individual attitude. So here, to answer the question, to answer this particular question, today we have the expert resource person here, Dr. SHEEBA Esgar. She is the director for Center for Women's Studies, National University of Advanced Legal Studies, Cochin. To have a word about her, she is quite charming. I have met her when I went to deliver a lecture under Suction program. She is very charming, pleasant, and peaceful always. I welcome her on behalf of the university as well as on behalf of our Honorable Vice Chancellor, Professor Dr. N.S. Santosh Kumar sir. I would like to welcome and express my gratitude to our registrar, Dr. Balaji. Due to administrative constraints work, he is not able to make his presence today, but my heartfelt thanks to him for all the support and kindness provided by him. I welcome all the teaching faculties, HODs of the departments, students, participants in and around India, and all my department students, my department faculties, and the technical support provided by the administrative staff. I thank one and all, and I welcome you all. Thank you.
Thank you, ma'am. Thank you for the gracious welcome, ma'am. So felicitation is an inspiration to others and motivation to whom you are felicitating. I take this immense pleasure to welcome one of the most lovable faculties of TNDALU, Dr. S. Rajalakshmi ma'am, coordinator of the webinar, assistant professor, head of the Department of Criminal Law and Criminal Justice Administration, TNDALU, to felicitate and honor the speaker of today. Over to you, ma'am.
Am I audible?
Yes, ma'am.
First of all, thank you so much for those wonderful, sweet words from a student. Thank you so much. Okay. What is necessary to change a person is to change his awareness of himself. A warm and healthy good morning to all of you. I would first like to thank our Honorable Vice Chancellor, Professor Dr. N.S. Santosh Kumar sir, Registrar Professor V. Balaji sir, and Dr. D. Bhuvneshwari ma'am, HOD Department of International Law and Organization, convener of today's program, for giving me the honor in felicitating our expert speaker. In addition, I add upon Dr. S.K. Ramani, Associate Professor, Head of the Department of Interdisciplinary Studies, Organizing Secretary of today's program. Thank you, ma'am. The Tamil Nadu Dr. Ambedkar Law University is actively involved in organizing many academic activities for the betterment of both faculties and students, even during this COVID-19 pandemic. One such initiative is women's safety. As rightly pointed out by Dr. Bhuvneshwari ma'am, as per the recommendations, observations of the 230th report of Department-related Parliamentary Standing Committee on Home Affairs on atrocities on crime against women and children by the Ministry of Home Affairs, Government of India, all the universities and its affiliating colleges are requested to organize online lectures and webinars on women's safety to make the general public aware of the dignity and respect of women. Sexual harassment of women at workplace has been one of the predominant concerns in the field of women's rights as it not only violates fundamental rights guaranteed under the Indian Constitution, but also causes ample harm to the physical and mental well-being of the victim. Today, we have with us Dr. SHEEBA as to create awareness on safety of women workforce and students in campus environment. It is a great honor for me to introduce and welcome our expert speaker. Madam completed her LLB in first rank with third rank from Kerala Law Academy, Law College, University of Kerala, Thiruvananthapuram in the year 2004. She took her LLM in Constitutional and Administrative Law from the Department of Law, University of Kerala, Thiruvananthapuram, securing first rank in the year 2006. She procured her PhD degree in law from the University of Kerala on domestic violence against women, nature of problem, legal and judicial response in 2012. Madam is a winner of Malor Govind Pillai Gold Medal and Justice M. Fatima Bibi Law Graduation Golden Jubilee Prize. Madam completed the research project on Protection Officers and the Protection of Women from Domestic Violence Act 2005, how far they are successful in providing solace to the victims, funded by the National Commission for Women in the year 2015. Madam has authored 4 books, including 2 booklets, and the latest being in 2021, titled Legal Awareness, a handbook for educational institutions. Madam submitted consultancy report on legislations relating to women to the Administrative Reforms Commission, State of Kerala in 2016. Madam prepared the draft policy on sexual harassment against women at workplace for the Government Medical College Ernakulam in the year 2016. Madam has to her credit more than 30 publications in reputed national and international journals and proceedings. Madam is an active participant of various international and national academic events. It is a privilege to read and hear her research contribution. Her research work is an eye-opener for further research. Madam, we are excited to hear your incredible speech. Thank you, ma'am. Awareness is a key ingredient in success. If you have it, teach it. If you lack it, seek it. Thank you, ma'am. Over to my student friend, Mrs. B. Parvadavardhini. Thank you.
Thank you, ma'am. It was indeed heartwarming. We have now reached to an integral part of this webinar. So before I hand the stage over, I would like to thank our Madam Speaker for sparing her valuable time and coming to our webinar to illuminate us on the safety of women workforce and students in campus environment. Madam, your exemplary contribution on various facets of women's studies and enhancing the awareness about the legal rights of women are very inspirational, and you are definitely a role model for many women out there. So here I heartily welcome the most ideal person for today's webinar, Dr. SHEEBA S. Da, Assistant Professor of Law, Director in Charge, Center for Women and Family Studies, NUALS, Cochin, to deliver the special lecture. Over to you, ma'am.
Thank you so much, my dear student representative, Parvadavardhini. Bhuvaneshwari ma'am?
Yes, yes, ma'am. Yes.
Yes. I'd like to proceed with your permission. Yes, ma'am?
Yeah, please. Yes, it's our pleasure. Please.
Good morning, everyone. Esteemed Vice Chancellor, Professor Santosh Kumar sir, esteemed Registrar, Professor Dr. Balaji sir, my faculty friends, respected Dr. Bhuvaneshwari ma'am, Rajalakshmi ma'am, and the organizing committee secretary, Professor Dr. S.K. Ramani, and my dear students. It's indeed privilege to be a part of this prestigious university. It's the first time I am attending a session, not a session, but the previous webinars I have attended. For the first time, I have been invited as a speaker to your university, and it is my privilege. With all your blessings and permission, I need to start with my presentation. Just give me 1 minute. I'll be sharing the PPT. It's been shared. Is this visible, ma'am?
Yes, it is visible.
Thank you, ma'am. Yes. Now, I am invited here to tell a lecture. In fact, session on safety of women workforce and students in campus environment. As Madam Bhuvaneshwari ma'am was pointing out, and Rajalakshmi ma'am in fact was pointing out, it's a part of
Ma'am, 1 second.
stipulations.
Sorry to disturb you. Full screen, ma'am. You can just bring it in full
Oh,
screen.
sorry.
PPT.
Yes.
Thank you, ma'am.
Yes, sir. Thank you. I believe it's been organized as part of the latest notification from the legal awareness sessions, including more and more women content-rich sessions or ingredients on women-related issues in the existing courses, conducting more and more webinars and the like. The notification issued in the month of April. Yes, with the spirit and with the same spirit, I'll be going ahead with the slides prepared by me. Yes. Women's rights are human rights, putting it bidirectionally. Women's rights are human rights and human rights are women's rights. As you know, this is a slogan or this is a phrase which has been coined or which is a basic philosophy under which the global South feminist movement started their initiative. And this has been initially launched by a Filipino women coalition named Gabriela. Launched as a part of the campaign. This slogan, or in fact the phrase, which was finally recognized and declared in the 4th UN World Conference on Women's Rights held in Beijing, 1995. And you know the value or the additions made out by this 4th World Conference held in Beijing. With this, moving on to the second slide. International instruments. Yes, it's only at the end of 20th century that we have seeing many of the feminist movements urging for recognition of the women's rights. In fact, earlier these gender issues were considered as something confined to women's section. Various feminist movements have been moving forward with the intention of bringing this human rights violation of human rights of women as an issue, not only in the United Nations, in the platform of United Nations and beyond that. As a consequence of that, we have seen a number of international instruments embodying or encapsulating various issues of violence, discrimination faced by women in the world. And starting with the Universal Declaration of Human Rights, as you know, it has been adopted in 1948. From the preamble itself, it talks about equality of men and women, right against discrimination, equal treatment, right to dignified life, right to personhood, right to womanhood, every aspect which is necessary to be a human being with dignity. All these aspects have been encapsulated under the Universal Declaration of Human Rights. And two covenants, that is the ICPR, the Covenant on Civil and Political Rights, and the Covenant on Economic, Social, and Cultural Rights, equally take note of these valuable inherent rights. I said valuable inherent rights. In fact, you know, the human rights, these are natural rights also. These are natural rights. Equality, that is a natural right. We all are entitled to get it, irrespective of whether a man or a woman. So Article 2 talks about equal protection. Article 3 talks about equality in enjoyment of rights. Specifically, I have included those provisions just for you people to understand what are the provisions under the respective covenants. Then Article 2, non-discrimination. 3 talks about, again, equality and enjoyment of rights. It says that there shall not be any discrimination on the ground of sex. All are human beings. And by virtue of being born as a member of the human community, you are entitled to human rights. Obviously, women is also entitled to human rights. She should be provided with just, fair, safe, favorable, healthy working conditions as well. That is Article 7. And that is very prominent as far as our session is concerned. We are dealing with workforce. Then finally, a comprehensive or an exclusive charter or a convention relating to the protection of human rights of women got reflected in CEDAW, the UN Convention on Elimination of All Forms of Discrimination Against Women. As you know, it was signed in 1980s by India and ratified only in the year 1993 with certain reservations. But still, we could take the privilege, or we are proud of being a signatory as well as subsequently ratifying the SIDA. Now, moving to the Indian Constitution, the basic document of the land, which is in fact the guardian of rights. From the preamble itself, we could analyze. It talks about equality of status and opportunity, ensuring justice to all. Then obviously part 3 and part 4 plus part 4A, fundamental rights, directive principles of state policies, and fundamental duties equally give emphasis to the rights of women, along with others, right? Fundamental rights. Take the case of Article 14. 14 to 18 talks about right to equality. It talks about general right to equality. There shall not be any discrimination. Simultaneously, it confers power to the state to take affirmative action whereby the so-called historically categorized disadvantaged or vulnerable sections could be brought under the protective umbrella. So 14, then 15 includes 3, 16, 1, 2, that talks about equality of opportunity in employment. Nowhere it is said that she has a right to employment. Nowhere it is said, but equal opportunity should be given. Then 19(1)(g), she is able to carry out any trade, profession, occupation, but in a safe working environment. That reflects, or that shows the duty, the consequent duty imposed on the state. Article 21, life with dignity. Then Article 23, right against exploitation, violences. Then ultimately Article 32, that is the lifeblood of the Constitution, which talks about your remedies, constitutional remedies. Moving to the directive principles of state policies, of course, you know that these directive principles are, in fact, these are guidelines to be followed by the state in the process of governance of the country. Yes, we always say that it is not enforceable, but still it has got its due recognition along with the fundamental rights. It's necessary. It should go together. Article 38 talks about promoting social welfare and creating a social order where justice is available to all. And as you know, Article 39, which forms the core of the Charter of Labor Rights, and women is also coming as part of the labor group. So right to adequate means of livelihood, equal pay, equal remuneration, then the protection of strength, health of workers, including women and child. Article 42 again talks about right to just and humane conditions of work, and it talks about maternity benefit. All these principles which you could see, or guidelines which you could see in the directive principles, it's in fact got reflected in various legislations. Then part 4A, ultimately the fundamental duties, and 51A E talks about protection or protection of the right to life with dignity of women, or it says that commonly talks about common brotherhood, fraternity, plus prohibiting practices derogatory to women. No one is permitted to do anything which is likely to derogate or devalue the dignity of women. So it goes like that. So what are the provisions under the international instruments, the provisions under the Constitution. Now directly moving to this slide. Gender justice, gender equality, and gender non-discrimination. This is in fact the core area which we'll be analyzing subsequently through the various slides. Just see the picture. It's a weighing balance. Already men folk is there in the other way. Then the women is there on the other hand. They are even now trying hard to get inside the way, right? Equality, they say. Who say? From the part of the government missionary, or others say, yeah, they have achieved equality by virtue of these legislations which is available in black and white. Equality, they say. But the ground reality is that they have not reached up to that level. But by saying that we haven't reached up to that level where we are in a position to compete with others, if I say it absolutely, it's what I am saying is something wrong. Because 1950, the Constitution has been brought into force, and now it's 2021. Whatever achievements we are enjoying, whatever benefits we are enjoying, is the fruit of the toil undertaken by our ancestors, by the various feminist movements. But I am not taking the courage to say that we haven't attained we haven't at least acquired relative equality, but we have much more distance to go so that we could compete with our counterparts. Okay, they say, yes. Now, we can see episodes of violence every day. Episodes of violence. Are we ready to subject ourselves to these violences? No. Then whom to be blamed? Whom to be blamed? Society? The governmental machinery? We, the women folk as such? Or the men folk? Whom to be blamed? So ultimately, this whom to be blamed has to be answered by us itself. And if it is like just casting blemishes on others, casting blemishes on others, we can do at any level. But it's not what this is not what we are supposed to do. We have to find out the lacunae. We have to find out what is this, what should be the best method to do away with it, confront and stop it. Now, we have enough laws in black and white. We have enough legislations. But are these legislations going to do something which society cannot do? I'm not saying that legislations are not needed. I'm saying that legislations are needed wherever which is necessary. Legislation should be enacted. Wherever there is lacuna, legislation should be redrafted, redefined, various provisions, etc. At the same time, some sort of support from society is essential. Without society support, no law could serve its purpose in its entirety. As you know, the two components, which is very much essential for bringing a law into force, the institutionalization and internalization aspect. So with respect to internalization aspect, yes, what I said is correct. Without society support, no law could serve its purpose. And how is that society going to react, going to act? Without understanding the basic rights, without understanding what exactly laws available to women against exploitation, how is the society going to react? If at all they react, it is without any basic foundation. That is something going to be doing the worst, not the best. So solution lies in creating awareness among the people as to what is law. What are the available legislations? What are the substantive rights conferred by each of these legislations to women? What are the methods whereby approach the institutional machineries incorporated under the respective legislations? Then how do we approach it, and what are the ways through which we could make use of this legislation so that we could do away with this violence, atrocities, and also the discrimination we are facing in the society? Whom to be blamed? That was the question. Now, moving to, as I said, we have enough laws. We have enough legislations, rules, regulations, equally judicial decisions, which shows a positive approach on the part of the government, plus judiciary, legislature, towards protection of the rights of women. But even amidst, we could see some instances like there is a sickening regularity you could see in continuation of these violences against women. So sources, first one, that will be Sexual Harassment Against Women, Prevention, Prohibition and Reprisal Act 2013, that is a POSH Act. Then what is the backdrop behind this POSH Act that you are aware? Vishaka was a state of Rajasthan, as you are aware. Even then, I'll just give a summary of what is the significance of that case. In fact, a social worker named Banwari Devi was gang raped. She was a worker under the state of Rajasthan, appointed under the state of Rajasthan. She was gang raped. And we could say that, this particular single incident that in fact induces authorities, but it's only in the year 2013 that act was passed. But still, that single incident, she is a victim at the same time. She is the champion behind protection of women's rights. Vishaka, in fact, Vishaka, that is a collective platform of various non-governmental organizations who filed the red petitions before the Supreme Court. It's a collective platform of NGOs. And as a result of this particular incident, the judiciary has got a chance to deal with sexual harassment at workplace. Even the extended notion of sexual harassment you could see in this particular case. Vishaka was a state of Rajasthan. So many guidelines were laid down, and it was stipulated that these guidelines have to be followed till a law has been enacted by the legislature. But what they have seen is that even after this, even after laying down these guidelines, many of the states and many organizations coming under the state was abstaining from instituting such institutional mechanism as is envisaged under the guidelines in Vishaka's case. So this Apparel Export Promotion Council versus AK Chopra, in that particular case, Supreme Court again got an opportunity to broaden the definition of sexual harassment. So if you define something, sexual harassment is confined to this particular aspect, it's like you are closing the door for the victims of sexual harassment who failed to bring their case under the closed door of sexual harassment. So this particular, through this particular decision, Supreme Court has in fact broadened the definition of sexual harassment by saying that it's not physical touch or a physical contact that is sufficient, that is enough to constitute sexual harassment. Even verbal abuse, sexual advance remarks, that is something, an unusual behavior that is directed against a woman, sufficient to constitute that particular action as sexual harassment, and she could claim the benefit. She could claim remedies accordingly. And the third in the series is the Mehta Kotwal versus Union of India 1999 decision. The same thing requiring the authorities to comply with the the guidelines issued in the Vishaka's case. Then ultimately, you know, this called the Judicial Charter for Women, the Bill of Rights for Women. That is the report, Justice Verma Committee report, the former Chief Justice of India. So this got, the report was submitted in 2013, and it is qualified as the Bill of Rights for Women or the Judicial Charter for Women. In fact, you could say that many of the recommendations were not implemented. A few of the recommendations were implemented, yes, but still we value Justice Verma Committee report as a charter of human rights of women. Now moving to the existing legislative provisions that is already there in the IPC, then the outrage in the modesty of women, then the criminal recent, the amendment, not the recent 2013 amendment, which is brought out soon after the Verma Committee report. Criminal Law Amendment 2013, that also brought significant changes with respect to this, tackling of violences against women. So many additional offenses have been incorporated under the IPC provision, 354A, B, C, and at the same time, they are not demand of the people to have gender neutral legislations also, gender neutral sexual offences legislations. And keeping that in mind, they have included some offences as gender neutral and some offences obviously as gender specific. Say for example, throwing acid, that was declared as gender neutral, but some other like stalking, voyeurism, that was brought under this amendment, Criminal Law Amendment Act 2013, was included in IPC. That was completely specified as, constantly specified as gender specific offenses. Then part of UGC, we have the UGC Section Report 2013. That is, it is prior to the regulations 2015. And this is this report talks about the need for gender sensitization and need to take measures for protection of welfare of women workers and female students in campuses. And under this report, you could see so many recommendations put forward by the UGC, and it is almost mandatory for the colleges and the universities to abide by these recommendations. So we'll be seeing a few main recommendations subsequently. Now, ultimately, the UGC regulation 2015. So these are the main sources. Now I just give a summary of the portion, then I'll be immediately moving to the regulations, because we are more concerned as an institution, as an educational institution, we are concerned with the UGC regulation primarily. So this POSHAT, as you know, this is the first legislation which gives emphasis to the protection of women against sexual harassment. From the title itself, it is clear, sexual harassment of women at workplace. Because this title is likely to bring certain other controversies we'll be seeing at the end. So this statute ensures right to work. It ensures secure and safe working environment. It enhances participation of women in workforce, then economic empowerment. This statute has got these following attributes. It's something promoting these rights of women. This statute, sexual harassment of women. So agreed women, the definition for agreed women, you could find in that. So agreed women means a person who is working in an organization, institution, department, by the government, whether organized or unorganized, visiting a workplace. So she may be assigned a particular task so that she need to visit another organization, maybe a sister concern, or it may be another completely different organization, but on the detection of the employer. So in such cases also, if she faces sexual harassment there, she has a remedy. Then it talks about student also. See, this also, the definition also covers student. It's interpreted to include student because some institutions does not come under the purview of the UGC regulation. So for them, if at all there as a student is married out with a sexual harassment, then she must be provided with a redress. So this agreed women has been included, has been interpreted to include a student also. Now, so a domestic worker, see, when you talk about unorganized workers, then we know that unorganized worker situation is really worse in our country. But in 2008, some sort of legislations were enacted, but still, in reality, they are facing so many issues. So what about a domestic worker? They have association. So it's one particular person going to one home and coming back. If anything happens in that inside that private house, what is the remedy available to? What is the choice with her? So domestic workers completely coming under the definition of agreed women. So it's a broader interpretation that has enabled us to bring in these categories also under the agreed women, whereby they could resort to the mechanisms under the POSH Act. So the regular, it can be regular employee, temporary, whether employed directly or indirectly. Say, for example, a person who is appointed by a contractor to the principal employer, then a probationer, trainee, apprentice, by whatever name any person is called, whatever name they are called, all of these persons are entitled to get a remedy, solely because they are entitled to be brought under the definition of agreed women. Now, moving to facets of sexual harassment. This is something which you could see in the Vaishaga guidelines also. What constitutes sexual harassment? It's not merely physical contact, or physical contact is sufficient to constitute sexual harassment. No, it's not like that. Even verbal abuse, sexual advances, sexually colored remarks, that is itself enough to constitute the offense of sexual harassment. So these are the attributes given to the term sexual harassment. Physical contacts and advances, demand or request for sexual favors, making sexually colored remarks, showing pornography, any other unwelcome physical, verbal, non-verbal contact of sexual nature. Then one question which is relevant here, how is it possible to understand that a particular action of an individual is not something unwelcome to me, or it's causing some sort of irritation, some sort of disturbances to me? Again, to understand that, we have to understand the nature of a particular, the feelings of that particular women as such. One particular incident, it's not necessary that one particular incident may be taken as the same effect, taken as in the same sense by two different ladies, having two different characters. By character, I meant a character, what do you say, whose character. So depending on the sensitivity, depending on the sensitivity or the sensitiveness of that particular action, and depending upon the nature of that particular, the feeling that particular person or the girl has got, you could define what exactly a sexual harassment is, because each person is distinct, unique. Now, what are the machineries? As you know, it talks about basically two machineries. First is the Internal Complaints Committee, and I would say that it is in the year 2016 there was an amendment to the POSH Act, whereby instead of Internal Complaints Committee, it was renamed Internal Committee. It's not so relevant, but still, I just want to bring it to your bring to your attention. Okay, the ICC, that is a 4-member committee that is to be considered by every organization. That's a mandatory thing. The composition of the committee is mentioned here. It's a 4-member committee, and said that 50%, at least 50% of the members should be women. And generally, it has got 3-year terms. Then 2 members of the employees committed to the cause of women. The selection should be, it's a nomination procedure. They have to be nominated by the employer. Okay, an employer is not a part of this committee. So the employer is distinct person. He's not a member of this committee. So ICC. Now moving to the local complaints committee. What are the situations where we need to resort to the local complaints committee? See, sometimes this picture shows an employer and an employee. So the sexual harassment, the harassment may be meted out by a person from a co-employee, or it could be from an employer also. Suppose it's an employer. An employer, he is constituting the ICC. Though he is not a member, he has got some sort of influence on the ICC, right? Even the recommendations of the committee is brought before the employer. So what is the remedy if the employer himself is responded? In that situations, you could refer the complaint to the local complaints committee. local companies. And again, if at all a person who is not covered under covered as an employee in any of the organization, so you need not think that he's left out. She has a remedy under the POSH Act by invoking the jurisdiction of the local complaints committee. So these are the two main situations where you could go to the local complaints committee, and the composition is slightly different. It's a 5-member committee, and it is constituted not in the organizational level, it's constituted at the district level, and it is appointed by the committee is appointed by the district officer. So the district office, in the place of employer, the district officer is in charge of this local complaint. Women, eminent women, then representation of women working in block, taluka. Then it talks about 2 members working in a non-governmental organization or such association committed to the cause of women. One of them should be 2 members, and one of them should be women. And and regarding the women member, it's further said that one of the nominated women members must be from the field of law, a person having expertise in law, or a women representing SC, ST, OBC, or even minority. That is again a further addition to the qualifications. Then ex officio member, social welfare officer of women and child development, by virtue of filing that office, he is the ex officio member. This is a minimum requirement specified to constitute an LCC. The committee and the internal complaints committee, these are the 2 machineries. And filing of the complaint, as you know, the complaint has to be filed within 3 months, that is 90 days from the date of the incident. It can be a situation where it is a continuous harassment faced by the lady. In such case, that 3 months could be calculated from the last incident. 3 months from the date of last incident, you have to file the complaint. Even if you fail to file it within that time period, sometimes there may contour. So on reasonable grounds, the committee may contour the delay. And sometimes the lady may not be able to file a complaint in writing. Then the ICC members, the chairperson or any of the members of the ICC can help her in filing the complaint. And if she is even she find it difficult to get the assistance of a chairperson or a member. Maybe it's not because the chairperson or the members are reluctant to give support, but some other reasons. If she's physically or mentally incapable of submitting the complaint, she can take the help of family members, legal heirs, friends, or any other person. Now, so we know that this is a long we're talking about a civil remedy. We want everything to be finished very fastly, because we are not in a process. See, something happens. Something happens yesterday to a women worker. How does she feel? Is she in a position to go to the workplace then very next morning? No, she won't be able to. She can't even think of going to that particular atmosphere again. For the same reason, there are persons who, for the they resign from their job. So this what is the net effect? It's like reducing the number of female participation in workforce. It's like doing away with the objective economic empowerment of women. So what we need an instant remedy. We need a speedy remedy to this. So we cannot wait till the entire process is completed. Though it talks about a specific time limit, we cannot wait even till that particular time period. So interim relief could be provided by the committee. It could be transferring the agreed women. So transferring the agreed women could be done only based on the request of the agreed women. So then granting leave to the agreed women up to 3 months, and this 3 months is an addition to all of the statutory leave she's entitled to get. An employer is duty bound to implement the recommendations, the interim measures suggested by the committee. Then it talks about conciliation. It said that so when we talk about conciliation, you may feel that, okay, well, it's a mandatory conciliation. Why should I go for a conciliation? I'm not ready to surrender my rights before others. Say, no need for taking that into consideration. See, conciliation is given as a means whereby if she wants, if she does not want to what do you say, make it up in some other controversies, if she want to make it in a what do you say, settle the disputes in a amicable, amiable manner, she can do that. So if it is at the request of the agreed women, conciliation could be continued, and settlement could be drafted, and the settlement should be submitted to the employer in the place of the recommendations. And it's possible that the conciliation terms and conditions may, but monetary settlement is not permissible. It's not permitted. Again, it is possible that the terms and conditions mentioned in the settlement may be violated by the respondent. In such cases, you have to take up the matter again to the committee, and the inquiry will be conducted according to the timeline, and the report has to be submitted. Yes. Now, these are the actions which is supposed to be taken by the employer based on the recommendations of the committees. So it could be considered as a misconduct in service rules. Then compensation could be given to the aggrieved women. And when you talk about compensation, certain factors have to be considered. Say, for example, the medical expenses arising out of the physical and the mental treatment she has undergone, the prospects in her profession, then the status of the parties, status of the respondent, all these factors, even the capability to pay the amount in lump sum, all these factors could be taken into consideration when they fix the compensation. Then other action, if it is found to be a slight deviation of normal behavior, then you could say that a mere apology, based on mere apology, warning, reprimand, that case could be handled, or that case could be closed based on these recommendations. Then withholding promotion, then withholding of pay rise increments, these are of a higher grade, higher in the sense, this is having a higher effect on one's professional life. So withholding of pay rise increments, termination of respondents for service, or requiring him to undergo a counseling session. These are the actions which should be taken by the employer. So it talks about obligations of the employer, and if the employer fails to comply with the obligations mentioned under the statute, then he is liable, and there's a monetary penalty up to ₹3,000. And if you continue doing the same thing, if say for example, he failed to constitute a committee, internal complaints committee, fails to conduct awareness program and the like, if it is offense is continuing, then it could be doubling of punishment. Even it can go to the extent of deregistration of the entity or revocation of the license. Yes. Now appeal, as I said, appeal to the tribunal, appeal to the court or the tribunal, that should be based on the specific service rules. And it should be shall be preferred within 90 days of the recommendations. Then some other salient features of statute is that everything should be done confidentially and in secret. There is a complete bar in publication of information or dissemination of information. Say, for example, revealing the name of the parties involved, the notice, the nature of the case. There is complete bar on publication of information. But it says that if it is for the purpose of enabling the other stakeholders to know that this sort of issues could be issues could be tackled by the ICC, it's like publicity to the existence, publicity as to the existence of a machinery for protecting women against harassment. Such sort of publicity is something permitted under the Act. Then before taking any action, principles of national justice has to be complied with. Then it talks about frivolous. Yes, always we say that there is a possibility of misuse of this law. Many of the gender-specific legislations could be misused. This is an off-coded statement, but this statute has taken out of that particular crisis by saying that the same punishment as is imposed on the respondent could be imposed on the complaint, that the women who is filing false and vexatious complaint. But that should be done based on an inquiry. Now, moving to this UGC regulation. UGC, prevention, prohibition, and redressal of sexual harassment of women employees and students in higher educational institutions. Even it talks about women employees and students. What is the ambit of, okay, women employees? Yes, only women employees. Students, should we need to construe that as women students? Yes, we will see what is the interpretation given to that aspect. Now, it is as per the UGC Act that the UGC has framed the regulation 2015. The source is given here, section 21 of the UGC Act and section 26 1G. That talks about the power of UGC to frame regulations. Now, moving to this regulation, UGC regulation 2015 gives emphasis to these following terms as such. It's very important. Employee, who is an employee? What is a workplace? What is the referred act? Sexual harassment, aggrieved women responded. Now we'll see who is an employee. It says that whoever mentioned as employee under the Post Act, any trainee, apprentice, internees, volunteers, teacher assistants, research assistants, whether employed or not, those who are related with any project, say field study, those are visiting the campus for a particular definite purpose or for a general purpose, short visits and short camps. Something which you can find under the post shadow, and this is confined to educational institutions. So even a person who is coming to a university as a short visit, maybe for some specific or a general purpose, or maybe a person who is engaged for it for the time being, for conducting the field study, he is also brought under the ambit of employee. So such a wider protection is given under this regulation. And in fact, when you go for a comparison between the UGC regulation and the post-share, you could say a broader spectrum under the UGC regulation compared to the statute. Yes. Now moving to workplace. Under this aspect, there are two connotations, two aspects important. Under definition of workplace, two aspects are important. First is, okay, yes, what do you mean by workplace? Workplace means the land or the premises of the organization or the university. See here, it's a university, educational institutions, colleges. Now, second aspect is the extended campus. What do you mean by extended campus? So the land of the campus includes the place where it is located, then any adjacent infrastructure facilities attached to this, adjacent infrastructure facilities to the university education institutions like bank counters, library, some departments, various departments in the same campus, university campus or colleges, sports institutes. These are the this is something coming under the original definition of workplace. Then what exactly extended campus? Extended campus means any place visited by the employee, the teacher or the student or any staff during the course of his employment or during the course of his studies. Maybe you as students, maybe you were sitting in another university or education as part of any cultural event. So it's not academic, but as part of cultural event, you are visiting that university, and we are facing such you are facing harassment in the campus, and then in a new campus. It's not your parent campus and another campus. Are you entitled to protection? Yes, you are representing your institution in a new campus, in a new incident, other institution. So you are entitled to get the protection under this particular regulation. Any transportation facilities, again, you could see the doctrine of notional employment, as if you are aware of the labor legislations, you could see what exactly the doctrine of notional employment, just extending the definition of workplace to related places also. If you are transporting the cab transportation conveyance mechanism to and from, yes, if it is arranged, whether it be arranged by your organization or not, that will be that space will be considered as a workplace. And field trips, study tours, internships, short-term placement, camps, cultural festivals, sports. In all these cases, you could see the application of this national employment, or sorry, extended campus. Even if you say national employment, as a teacher, as an employee. The other one, student, extended campus interpretation. Now, sexual harassment under the regulation, it talks about two aspects. One is the quid pro quo, that is consideration. If you subject yourself to my demands of sexual favors, then you'll be provided with some preferential treatment. Maybe you'll be provided with promotion very immediate. In the next day, you'll be given promotion. You need not go with the performance appraisal system or the like. No, that is quid pro quo in consideration. Next is hostile environment harassment. That is, if you do not subject yourself to my demands of sexual favors, then you'll be facing detrimental effects, in the sense that there is the three explanations given below. So you'll be facing a hostile working environment. You won't be able to carry out your duty in a peaceful manner. There's always a threat attached to it. That is hostile environment harassment. Now again, this agreed women that, we have seen that. Now a student, suppose you are a student pursuing online educational distance mode, or an online mode, or maybe a regular mode of, if we are pursuing a regular mode of course, then there is no confusion as such. But in the case of distance mode and short-term programs, there is a confusion. So no need for such confusion. It's specifically mentioned that the student undergoing any programs, whether online, regular mode, or short-term programs, in all these cases, you are entitled to be recognized as a aggrieved person under the regulations. Maybe a student who is about to take admission in the university, not yet completed the entire process of admission. Is she entitled to get a protection under the regulations? Because can she be considered as a pure student in the strict sense? Because she is not admitted. The entire procedure is not being completed. yes, she could be considered as a student, even though she's not absolutely admitted to, in the strict sense, admitted to the university. Yes, moving to the respondent. This term is creating creating some confusion whether it talks about male only or female. Respondents could be female also, but the statute itself, through its provisions, makes it clear that it talks about respondent could be male or female. I'll come to that. So again, third-party harassment. Do you know what exactly third-party harassment? It's a harassment meted out to a person. It's a harassment done by an outsider, not a part of the organization of the university or the college. From outsider. Do you think that there is a remedy against third-party harassment? Yes, there is a remedy against third-party harassment. It's possible that even the rule strictly says that. Even you talk about POSHAT, even there also you could bring in third-party harassment. It's possible for the employer of your parent organization to contact the employer of that outsider if he is employed. If he is employed, it's very easily. Otherwise, you could approach the collector. Then, if it is a compensation, if a compensation is recommended by the ICC or the LCC, then the compensation could be recovered as if it's a recovery of revenue. Revenue recovery procedures, you could get the compensation. Now, moving to the grievance redressal mechanism, yes, ICC, Internal Complaints Committee. Earlier, prior to this ICC, we had the gender sensitization, gender sensitization against sexual harassment. Gender sensitization against sexual harassment committee, that was there. But it is specified in the regulations that whatever committees in whatever name it appears, that has to be renamed as ICC. Internal Complaints Committee. So obviously it is different from what you have seen under the POSHAT. Women presiding officer, and she should be a professor in the university. If it isn't the case of college, associate professor or reader in colleges. So there can be situations, there can be exceptional situations where there is no professor in the university, women professor in the university. How do you appoint the chairman, the presiding officer? It could be any senior employee of the university, need not be a faculty as such. So 2 faculty and 2 non-teaching employees, that is the next composition. Then 1 member representing NGO or a person having expertise in legal matters, issues relating to women. Then 3 students, obviously, especially when the matter is relating to a student, where student issue is being considered by the ICC. The 3 students could be included, and they have to be appointed on a democratic basis. It's not necessary that for all the complaints being handled by the ICC, the students must be allowed to hear and give their comments. Not necessary. Only if it is a matter relating to the students' issue, they must be present. So the 3 years is the normal time period for the members of the committee, and it's possible that for the university or the colleges to specify that, okay, we move forward with a policy that 1/3 of the members changes every year. It is left with the university. At least 50% of the members shall be women, and it is mentioned that allowances and fees to be given to the nominated member. Now, functions, these are the functions of the ICC. As you have seen, the obligations of the employer under the POSHATs, in the regulation also, you could see obligations on imposed on the employer, plus equal obligation on the part of the ICC. So these are the functions of the ICC. Basically, they are aimed at their functions to ensure a gender violence-free campus, and provide all assistance to the women employers, teachers, staff, and students to get their grievance through the procedure, providing the complaints and conducting a so procedure under the regulation has to be followed. Within the limited time period, everything has to be expeditiously and confidentially adjudicate. Not adjudication. They have no right to take decision. They have to come with recommendations. Close the decision. Close the complaint as such with recommendations. So the process of inquiry, just the same 3 months time period, you could see in the regulations also, and the copy of the complaint. So whenever a complaint is received by the ICC, the copy is to be given to the respondent within 7 days. This is a timeline given. Reply within 10 days with documents and details of witness. See, many cases as part of the this ICC Government Medical College, I have seen that file complaint just mentioning I face such as I face such a mistake on the part of my colleague. They don't even go into the. So what happens is that we are supposed to give directions to them. We're not supposed we give directions to these persons to come with a new complaint specifying the event very clearly, the date in which it happens, there is any witness, all other things you have to include in it and resubmit it. But when they resubmit on a next date, on a later period, we don't consider it as a submitting the complaint on that later period, but we take it as the complaint submitted on the first day itself. So in order to avoid such confusions, better that you should give enough publicity of the policy, sexual harassment policy of your university. Reply within 10 days with the documents, then the inquiry has to be completed within 90 days after receipt of the complaint. Then the inquiry report has to be submitted to the administration within 10 days from the completion of the inquiry. And it is then left to the employer to the officer of the higher education institution to go ahead with the implementation of the recommendations. If he fails to implement, then he has to face a repercussion. So this is part of procedure. Again, appeal has to be filed within 30 days from the date of recommendations to the executive authority of higher education institution, or whatever mentioned in the service rules or the related rules apply to each of the agreed women. It's possible that the executive authority decide not to act on the recommendations, but they have to specify the reasons why they are not acting based on the recommend. It's possible they can take that decision also, but reasons are mentioned. And it has to be properly communicated to the ICC and the parties. And again, before taking any action against the respondent, they have to they be informed to give shockers notice as to why that action should not be given against him. And the respondent has to answer within 10 days as to why such an action should not be taken against him. And conciliation, that is also mentioned, said that wherever possible, it is better to make use of the conciliation procedure, conciliation mode given under the regulation as well as the statute, but it should not be based on a compulsion of the agreed women that conciliation should be initiated. If it is at the instance or the request of the agreed women, yes, they are all happy. But again, there should not be any monetary element. There should not be any monetary settlement of the dispute as such. And it may even happen that they may be filing complaint. The agreed women may be filing complaint, but she failed to appear before the committee. Even the respondent, after getting notice, he failed to appear before the committee. So what happens then? Is it possible for the committee to close the complaint and then completely went up with that? No, they have to see whether they have been continuously absent for three consecutive hearings of the committee. And if there is no response, and if it is found that there is no genuine reason behind their absence from appearing before the committee, then if there's no genuine reason, they can close the proceedings and they can give the decision they can come out with the recommendations accordingly. But before taking that, coming to a conclusion, they have to give 15 days notice in advance that we are about to close the proceedings accordingly. Now, interim orders is the transfer of the complainant or respondent. Then leave with full benefits. Then some sort of, see, for example, if the agreed as a student and the respondent is a teacher and he's constantly involved in evaluating performance, academic performance, or the examination papers, then in such situations, it's possible that the committee recommends this particular this particular teacher being prevented from evaluating or involving in the evaluation process. That is also possible. Then ensure effective distance between the parties. Even the respondent may be restricted from entering to the campus. So what is whatever necessary to ensure a conducive environment for the women employees, conducive environment of safety and protection against possible victimization, that should be done. That should be done or meted out through the interim orders. Then punishment, somewhat similar to what we have seen under the POSHAD. But here, being an educational institution, it has to be done as per the civil service rules. If it is student may be with all the privileges so far being enjoyed by the student may be withheld. He may not be she or he he or she may not be permitted or should not be permitted to make use of the library facilities, scholarship allowances, withholding of any of the scholarship she's getting, then striking of the names from the roll. In some situations, reformatory punishment may be resorted to, like requiring the respondent student to session or involved in community services. So here also the compensation is possible, and the false and in case of false and malicious complaint, the same based on an inquiry and based on the report, the same punishment as is given to the respondent could be imposed. Responsibilities of the employer, yes, zero tolerance policy. Again, what we have seen is that UGC regulation 2015, it's a guideline, or it is the parent instruction to be followed by all the institutions, all the universities, educational institutions, colleges, yes. But at the same time, to be more specific as to what is the policy of a particular institution, as in the case of sexual harassment, is always better. Even it is mentioned in the regulation that each of the institution can come out with a strict policy on sexual harassment. And in that policy, it's possible for the institution to specify that this is a general neutral sexual harassment committee. It's possible, but they have to specify that it is a general neutral sexual harassment committee we have under our campus. So even the aggrieved person could be a woman or a man. It could be of a transgender. So, but that should be specifically explicitly mentioned under the policy. So it's better that all the institutions should have a policy, separate policy of sexual harassment. It's called anti-sexual harassment policy. So dissemination of information. This I was referring to the Suction report 2013. I think I am exceeding the time. I'll be confining within 10 minutes. Bhuvaneshwari ma'am, can I go ahead?
Ma'am, yes, ma'am. Go ahead, ma'am.
Yes.
Yes, ma'am.
Sorry, just give me 1 minute. Yes. So responsibilities of employees, regulation. Yes, ma'am. Responsibilities of employees, regulation 3, and it is also a requirement that the educational institution have to submit timely reports to the UGC plus the reports to the employer, in the sense higher executive officer of the higher education institution. And again, moving to, yes, just a minute, ma'am. Yes. Yeah, supportive measures. Certain supportive measures are also included under the regulations. Supportive measures, say for example, in order to ensure a violence-free campus, it's a duty on the part of the employer or the educational institution to make sure that gender-sensitive doctors and nurses, or the services of gender-sensitive doctors, nurses, gynecologists be made available to the students. Then in the case of yes, they can run hostels. And again, one important thing is that in the name of securitization or in the name of safety, or always there should not be over securitization. In many cases, we could see that in hostels, college hostels, men's hostel will be there, girls hostel will be there, and many a time it's a curfew, no? Though it's not the proper usage, but people used to say like that, curfew. Many the girl students are required to enter the hostel before 7. But extension is given to the boy students. Many times they come with the complaints that why is this discrimination? Yes, it's a discrimination. Why are we compelling the girl student to enter the hostel building before 7? And simultaneously, when the boys are given the freedom to walk around in the campus even after 10. So in the name of securitization, we should not curtail the freedom of those women. Instead, what we have to do is that the university can take some supportive measures like proper lighting of the campuses. Everywhere nook and corner should be properly lit. Then there should be sufficient number of women security personnel and gender sensitized security personnel. Then if it's a the large campus where it's necessary to walk kilometers to reach the hostel, at least provide even during night, because libraries always work during night also. So at least provide them with a transportation facility. So all these supportive measures could be taken. Even the Suction Report 2013 talks about it's necessary that the institution should set up CCTV cameras at every nook and corner so that any such issues of violence could be instantaneously understood and proper actions could be taken immediately. Now, so what will be the action that UGC will be taking for non-compliance? Yes, it's clear. Withdrawal of declaration of fitness under Section 12B to receive grant from UGC, and removal of the name of college or university from the list maintained under Section 2F, withholding of any other grants, declaration of ineligibility for any assistance under UGC special or general program. Then, recommends to the appropriate, even they can, if it is a state university or central university, they can recommend to the UGC, can recommend to the central government or the state government, asking them to withdraw the recognition to the concerned university or the affiliated colleges as such. If these are the actions, likely actions that UGC could take against non-compliance of these regulations by the educational institutions. So UGC's action report I have already mentioned. I'll be sharing the slides. If anyone want to go through the intricacies of this, you can do that. Now, Criminal Law Amendment Act 2013, it was one which I read the initial slides, and which talks about gender specific offense and gender neutral offense. Voyeurism, stalking, everything was coming as gender specific. So this is an additional resource for protection of women against sexual harassment. Now, observation of the judiciary, 2 or 3 slides. Vidya Akhar versus Union of India and others. It's a High Court decision, Bombay High Court decision. It's a case where a writ petition was filed in Article 226, challenging the order of disciplinary authority and the report of ICC. This order was challenged by the aggrieved women, saying that the ICC proceedings were not in accordance with the Act or the regulations, and even the disciplinary authority who was asked to review the report of the ICC or deal with the dispute, they haven't acted in a fair manner. And she was saying that even in the report, they didn't mention about the guilt of the respondent. Though the respondent was given a punishment, in the form of punishment, he was asked to shift to the other campus, or a transfer order was given to the respondent. Even in the report, you can't find a single statement which says that the respondent is guilty of harassment. So that is something lacking in the report, and she was so disturbed with such a report, which is something which she considers as something not taking this the harassment as a serious thing by the Internal Complaints Committee itself, which is a body entrusted with the task of ensuring a the conducive working environment for women teachers and the students, right? So in that particular, while dealing with the case, the High Court was referring to the decision given by the Supreme Court in Kumar versus Union of India, just to understand or just to emphasize that in which all situations it's possible for judiciary to interfere with the decisions of the disciplinary authority. In that particular case, Supreme Court has clearly laid down that judiciary can interfere with the actions or decisions of the disciplinary authority, provided there is a violation of principles of national justice. If the order is shockingly disproportionate, then it's contrary to law, relevant factors were completely neglected, and irrelevant factors taken into considerations, as you know, there's being the students administratively, the bias is reasonable. Those grounds and categorically brought in by Supreme Court in Kumar versus Union of India, and that has been relied on by the Bombay High Court for arriving at a judgment in Vidya Akhar versus Union of India, saying that this decision is not improper or disproportionate. Yes. Now, one of the big question is, can respondents be persons of same gender? Can respondents be persons of same gender? Yes, that has been, it's not purely based on a judicial decision. We could say that even otherwise referring to the provisions, keenly going through the minor, you could say that yes, it could be persons of same gender. Again, respondents can, it be respondent is confined, the term is confined to the women only, Again, going to the provisions, it could be said that it's not confined to women only. See, they're referring to the case Malabiga Bhattacharjee versus ICC, Vivekananda College and others. Again, a Calcutta High Court decision. So, referring to Regulation 8.2, respondent shall file his or her reply. Once a complaint is received by the respondent, he or she, the respondent shall file his or her reply. So that shows that respondent could be male or a female. So that dispute is over, that controversy is over, confusion is over. Then section 2M. Respondent means person against whom agreed women has made a complaint under section 9. It talks about the Post Act. Section 2M. Who's the respondent? Respondent means person against whom agreed women has made a complaint under section 9. It talks about person, male, female. Then, so same gender sexual harassment complaints are maintainable under the Post Act as well. So under the regulations plus the Post Act, same gender sexual harassment complaints are maintainable. Then, as I said earlier, when you go for a comparative analysis, the spectrum is broad as far as the regulation is concerned, but that is the other one, the Post Act, is comparatively narrower. Regulation 3D says about responsibility of higher educational institution. It says that higher educational institutions should be gender-based violence. And it says that all violence is faced by people, irrespective of sexes, even male students or students of third gender. That is, all those issues of sexual violence is faced by these vulnerable groups can also be dealt properly by the higher education institution. So what does it mean? Whether the ICC under this regulation talks about bringing all these vulnerable groups also under the purview of ICC, or again, moving to the next session, supportive measures. Regulation 3.2, it talks about enabling committees. I just want you people to go through these two regulations. Enabling committees to be sensitive to deal with vulnerabilities on account of region, class, caste, sexual orientation, minority, differently even. What does it mean? ICC is one complaint that is dealing with sexual harassment against women. Enabling committees, it's possible. There are two connotations possible. First is that through your policy, through your university anti-sexual harassment policy, you may specify that the same ICC, which is constituted under the UGC regulation, will deal with sexual harassment cases against the so-called vulnerable groups, maybe based on sexual orientation, the transgenders, or even some male students who are so vulnerable to these sexual harassment issues. So in the policy, you can specify. Or you may set up enabling committees specifically for those issues. Both are possible. It's left to you to specify it in the policy. Now, so the Post Act, again, the Post Act also says respondent means any person. And section 3.1, but section 3.1 of that says no woman shall be subjected to sexual harassment. So what should we infer from that? Agreed should be women, or it can be man and woman. So far, we don't have an interpretation strictly says that the Sexual Harassment Against Women at Workplace Prevention, Prohibition, Reprisal Act encompasses both men and women. But we could see a positive, I don't know whether it's positive or not, but I feel that there is some, the approach of the court is reflected in one of the decisions which I have made. So it says, sexual harassment is not a static concept. It has to be interpreted against the backdrop of social perspective. The sense that when the society changes, when more and more vulnerabilities are identified, vulnerable groups are identified, it's inevitable that we should accommodate those peoples also under the respective, I would say respective committees, need not be brought under the same ICC, because the very statute, even the regulations, the names start with women. OSHA also talks about women and sexual harassment against women. So it's better that we may deal with the enabling committees. Even I believe, even I do say that there are universities in their sexual harassment policies mentioned that this is a gender neutral sexual harassment policy. That means sexual harassment complaints by male or a female, a girl student or a boy student, even transgenders can be brought under the purview of the ICC. But it varies with the university's decision. Even as far as service rules are concerned, even as far as the labor standards are concerned, we have the standing orders, right? Even the standing orders, you may the employers may specify that yes, the policy written by us is gender neutral. By that, you can solve this particular issue. I think this is the end of this. The end of my session. Yes, with a few concluding remarks, I could come to the last slides. So episodes of violence should cease by proper intervention. Yes, we know that episodes of violence should cease. And we have proper intervention in the form of black and white laws, in the form of executive machineries. Then we have certain commissions, well-drafted commission reports as the Justice Verma Committee report. Everything is there. But what is the law in it? Now, openness is a means. Yes, the employer has got a duty, the ICC has got duty to publicize the, create awareness among the people as to the existence of such a machinery, protective machinery legislation. Yes, openness is a means. The end has to be safety and security. Then when you refer to, 2011 says that 48.5% population is women. And we value, it's a proud moment. We have to accept that our life is to be treasured. We constitute 48.5% of the entire population. Why should we be neglected? We are contributing much towards the economy. We are contributing much towards our family. Everywhere we have proved our signature. Then why this discrimination always been faced by the women? It was simultaneously recognizing the fact that apart from the women found, there are a few other vulnerable groups also. But when we are asked to say for women, I confine my wordings to protection of women only. So it's time that we should do away with, or we should abstain from that patronizing patriotic, the notion of women being the weaker section. We should do away with that notions, and we should come forward. We should even promote the students, even our colleagues, to come forward. Myself, we should come forward and speak against these harassment, because silence is not a, though we say we have a freedom to silence, silence is not a remedy for anything. We have to confront and stop it. And this should be our motto. But with the limitations, with the permissible limits, keeping in mind the constitutional values, everything, we should confront and stop it with respect only. Now, with this, I'm winding it up. I have included so many slides. I was not able to justify myself, but still, yes, I'm concluding now. Thank you all. Thank you, ma'am.
Thank you, SHEEBA,
Yes,
for
ma'am.
that a very wider comprehensive lecture we have here. We have certain questions posed by the students.
Yes, ma'am.
You can explain.
Do I need to go through the chat box and explain it by myself? I can't see the chat.
Thank you, ma'am.
Do I need to go through the chat box and find the questions and answer accordingly?
Yes, you can proceed, SHEEBA, if you are able to see.
Yes, I can hear. I can see that, ma'am. Let me find the first question. So many questions. Oh, yes. The first question, we can see are the transfers also? Is this the first question, ma'am? Yeah.
Ma'am, we have questions. Shall I read it out, ma'am?
Yes. I'll take it from the last question. Okay.
Okay, ma'am.
It's easy to find it. So many questions are there.
Ma'am, you want me to pose the question?
What is the punishment if a third person threatens or from the last? Or I think I can do it. I can do it by myself. If I'm starting from the last question, it's very easy for me to answer to all the questions. Okay, I'll do by myself. What is the punishment if a third person threatens or forces a woman to give a malicious complaint against a particular person? Third person threatens or forces a woman to give a malicious complaint against a particular person. So anyway, women is filing the complaint. Again, I said, based on inquiry, if it is proved that there is a malicious complaint made by the women, she'll be tackled accordingly. She'll be imposed with the same punishment as is imposed on the respondent. Again, the fact that she's being compelled, what is the relevance there? If she could prove that she is compelled, anyway, she has filed a complaint. How could we deal with it otherwise? she has filed the complaint. Or else you have to prove, if she has to prove that I have been compelled, induced by third person to file a complaint, maybe for some other benefits, maybe as part of a revenge of the third person against the respondent. There can be situations like that. What is the presumed what you have perceived is correct, but that has to be proved. Then only she could find escape from the punishment. Otherwise, she will be opposed to the same punishment, I think. Yes. Now, is it right time that we should make a complete paradigm shift from preventive or reformative to more punitive applicable for frivolous complaints as well? Complete paradigm shift from preventive or reformative to more punitive applicable for frivolous complaints. So when here also I could see emphasis given to the false and vexatious complaints against, filed by the women. See, usually we don't, we as a women folk, we don't take it as a means to take revenge against another. It's a general principle. Yes, I know there are persons who are making it as a means to take revenge others. So complete shift from preventive, reformative to punitive, I don't think so, because there may be situations where, as I said earlier, the way in which a particular action is perceived by me, by I as a woman, may not be the same way others do. Maybe I'm from 1980s, right? So you people from 2000 or 2020. Oh, so you maybe may not feel the same, you may not have the same feeling when you are being touched on your shoulder by your friends or be colleagues. Because the gap also you could see, I mean from 1980s, you are in 2020s. Huh? I'm not blaming anyone, but the extent you could bear as a normal touch or a normal behavior, to that extent, okay, you are fine with that. But when I feel that keeping shoulders, because I don't permit anyone to keep hands on my shoulders. But if anyone does against my wishes, I feel something, some unusual behavior, I can't adjust with that. So I may file, even if I'm asked, I'm taking not my example. If you are asked by, or you're given an offer by your colleague, can we go for a cup of tea? So that same phrase, same sentence, the same offer could be interpreted in two different ways by two different persons. So there are situations where you need not impose a particular respondent with severe punishment. That may be a slight deviation from the normal behavior, slight deviation from the normal behavior. So for that, why should we impose with such a punitive? Why should we give that much punishment? Proportionality, what does it say? Proportional to the offense, proportionate to the action, the wrongful action, the offense, right? So complete shift, I don't mind, because even in the regulations as well as under the portion, you could see both the preventive, reformative, and punitive. All these aspects have been given, even under the normal codes followed. You can't see a complete shift from preventive, reformative to punitive. What is the punishment for malicious complaint given by women? Yes, I mentioned the same punishment as is imposed to the respondent. Ma'am, kindly throw light on burden of proof under the POSH Act. Burden of proof under the POSH that I mentioned. Then, again, one more thing I would like to mention. See, in cases, basically, generally in almost all sexual harassment offenses, as a agreed women find it difficult to include the names of witnesses because it is taking place in private. Even the respondent may be so tactful that he is trying to find out a particular time and a space where he could make use of or he could reflect his sexual desires or the like. So many often you can't find a witness. So it's difficult. Again, as a supportive statement, you could say that even the statute says that even if you fail to prove the allegation, even if you fail to prove the allegation, you have to prove it. If you fail to prove the allegation, then that won't be considered as a false and malicious complaint filed by you. Because when the statute says that for false and malicious complaint, the women will be punished as same as that of the respondent. If you fail to prove your proved that particular act of sexual harassment, that won't be considered as a that your complaint is you have filed the complaint maliciously with malice intention. Yes. Then just a minute. What is it? Just complaint. Ma'am, kindly throw light on burden of proof. This one I mentioned. What is the difference between sexual harassment and gender harassment? Yes, earlier, the term gender justice. Even you know that the feminist movement started early in the by the end of the 20th century. Even some glimpses you could see from 1980s onwards. But even at that time, it was considered gender violence is something confined to women only. But gender is a broader definition. It's not confined to the sex, male, female, but biological differences based on that. But gender includes, it's not confined to sex as such. So, sexual harassment, gender, that's what I said. It's not confined to, the protection is not confined to women only. It could be made available to a man also, but you have to specify in the policy. Transgender also. Trans women, trans man. So it's different. It's not based on your sex or biological differences. Then, suppose hypothetically, a speaker from different organization comes to university B being B for some event. Yes, now C, not a student of C, not a student or employee of B university, a participant of the event. Yes. See, here the concept of third-party harassment is also involved. First of all, suppose 3 universities, you are mentioning here 3 who's responsible for education, A, B, C, all are from different organizations, A, B, C, all are from different organizations, yes. And you are attending a function in another university. Yes, okay. So 3, maybe A, B, C are attending a cultural function in university. Yes, I'm taking this hypothetical situation. A, B, C appointing a cultural function in university X. So you may be representing your university in university X, right? So there are 2 interpretations possible. First is that your parent institution, because you are nominated to attend, or you are permitted to attend that cultural function in another university. So it's like extended campus. Your university can take action. First thing. Then nothing prevents this host institution from considering this issue, from taking this issue under their ICC also. Nothing prevents, because even a person who is shortly visiting your institution, even here the university X is organized as function, and where to attend this particular function, the other universities has nominated you. So being you then become a part of the part of this university X. So it's possible for the university X also to take this matter. Again, I said a person who is not a student, who is not officially admitted to the university. She's not officially admitted to the university, but still she could seek help under the ICC. How is it possible? She is not a student for the time being. She's about to take admission. So such a broader interpretation is possible. Hypothetically, no, what you are the transgenders also covered under Act, which is implemented for the women's safety, like POCSO and other provisions given under Indian law? Yes. Transgenders, it's possible. You have to specify under the policy, respective policy. But as far as POSH Act is concerned, in the title, even in the UGC regulation, you could see women employees and students, but it's given a broader interpretation. That's possible if you specify in your policy. Under the POSH Act also, I said, even the employers can specify in their, even in the standing orders or another policy, that our sexual harassment, anti-sexual harassment policy is gender neutral. It's possible. It's possible. But you have to specify in your policy. Otherwise, it's not. We can say against transgenders are also admitted. Yeah, I think to mention POCSO. Yes, POCSO, Protection of Children from Sexual Offences Act. POCSO is a gender neutral legislation, right? It's a gender neutral legislation. So there is no question of, there's no need for bringing this issue here. It's gender neutral. Yes, not sex neutral, gender neutral. I'm not sure whether you're satisfied with the answer, but still I'm going on. Transgender is also happening daily, but it's not given enough importance like and then I've answered. Husband, kindly share your views and thereon. Yes. Criminal law raise voice about the same thing. Welcome queries from the participants. You have any questions? Yes. Yes. I think I'm done with that. Is there any question left out? Yes, ma'am. Bhuvaneshwari, ma'am.
Yes, our patients are answered, Deepa. Thank you.
Yes, ma'am. Thank you so much, ma'am. I'm not sure because usually I go for offline sessions. I think only one online session I did this time. But this is the I consider this as a most precious session. I'm not sure whether any flow was there from my part. If there was any
Very
flow,
well done. It's very well done. All
anyway,
provisions you
even
have
I'm
covered.
taking in advance. Yes, ma'am.
All provisions you have covered. Constitutional provisions, committees, policies, everything you have covered. And the UGC guidelines is new. For some people, it will be a new guideline. Will be knowing. So you have enlightened us on all the provisions. Thank you very much for spending
Yes,
your
ma'am.
valuable time.
Okay, thank you, ma'am. Thank you, dear students, dear participants. Thank you, all my teachers. Thank you.
We have what
Thank you so much.
SHEEBA. Yes.
Yes, ma'am. I'll read, ma'am.
Thank you so much for your words of wisdom, ma'am. And thanks for patiently answering all the questions and giving a well-grounded understood all the nuances and various aspects of the legislation that is enacted for the welfare of the women workforce. So we completely understood the lecture, ma'am. And as gratitude is virtuous form of thought, I would like to invite an enthusiastic personality, Dr. S.K. Ramani, ma'am, Organizing Secretary, Associate Professor, HOD in charge, Department of Interdisciplinary Studies, PNW, to propose the vote of thanks. Over to you, ma'am.
Can you hear me? Hear me?
Yes, ma'am. Yes, ma'am. We can hear you.
Thank you, Dr. SHEEBA, ma'am, for a very wonderful, elaborate lecture. I just want the formal vote of thanks. On behalf of the organization committee, I propose the vote of thanks of this UGC Gender Sensitization National Workshop on Women's Safety, organized by the Department of International Law and Organization on the most debatable topic in contemporary era, with regard to safety of women workforce and students in campus environment. My sincere thanks to our Honorable Vice Chancellor, Professor Dr. N.S. Santosh Kumar Sir, for guiding us to conduct various academic activities virtually and granting permission for the same. Thank you, sir. We are sure that we will march ahead as per direction to take university to greater heights. Professor Dr. SHEEBA is Director, Center for Women and Family Studies, the National Institute of Advanced Legal Studies, Kochi, the chief guest of today's webinar. Madam, at first I have to thank you for choosing this topic, safety of women workforce and students in campus environment, which every institution should strictly enforce and follow. Madam's experience in research related to the issues of women has greatly reflected in her deliberation and discussion of this topic. The message carried through this webinar results in a success only through its strict implementation. Thank you, madam. This special lecture should have benefited a lot to each and every participant, irrespective of their gender, and hope we will travel in a cafe environment. Thank you, madam. My sincere thanks to our registrar, a dynamic person and humble person whose support has facilitated us to conduct virtual programs. Thank you, sir, for all the support for smooth conduct of the webinar. Heartfelt thanks to Dr. Rajalakshmi, webinar coordinator and HOD Department of Criminology, who felicitated the webinar in her sweet, tender voice. Madam, a person of humbleness and sincerity, thank you, Dr. Rajalakshmi, for your felicitation of this. Thank you. The convener of the webinar, Dr. D. Bhuvaneshwari, HOD, Department of International Law and Organization, who introduced the webinar topic and inspired the participants through her welcome speech. Madam is always a person of motivation and instrumental behind to organize webinars for the benefit of the students. Thank you, Dr. Bhuvaneshwari, for the welcome speech. I render my thanks to the Controller of Examination, Dr. Srinivasan, University Librarian, Dr. Ashok, to all the professors and to all the head of the departments, my colleagues. Thank you all for all the support. Heartfelt thanks to all the participants and faculties and principals who participated in the webinar from various government law colleges, national law schools, and law universities within the state and outside the state. The organizational committee renders a special thanks to the technical support team for broadcasting the webinar, without whom this would have not been, and to all the administrative staffs of the university. My words of appreciation and special thanks to all the participants and especially the student participants of various institutions for registering yourself and actively raising your doubts and questions related to the workshop. Thank you all students, participants. Last but not the least, the student coordinators of the webinar, Ms. B. Pavadarani and Ms. B. Kamalapriya, LLM students of Department of International Law and Organization, who coordinated with the webinar committee members for a successful conduct of the webinar. Thank you all for all the support. Thank you.